Today on this episode of Law Weekly, we talk more about the alleged defamation case of Lagos-based lawyer Dele Farotimi against Senior Advocate of Nigeria, Chief Afe Babalola, and the justice system in Nigeria. We have the views of Senior Advocate of Nigeria, Candide-Johnson. Also showing on the program, the Attorney General of the Federation and Minister of Justice, Senior Advocate of Nigeria, Lateef Fagbemi, faults the Governor of Edo State, Monday Okpeholo, on the suspension of local government chairmen in the state. Plus our recap of the top trending stories in the news. Hello and welcome to the program. I'm Shola Shoyeli. It's no more news that the Chief Magistrate Court in Ado-Ekiti, Ekiti State has granted Lagos-based legal practitioner Dele Farotimi bail in the sum of 30 million naira, 16 days after detaining him for alleged criminal defamation of Chief Afe Babalola. As part of the bail conditions, Chief Magistrate Abayomi Adeosun ordered Farotimi to provide 2 sureties who are responsible citizens of the country, and one of them must own property in Ado-Ekiti. The court also barred Farotimi from granting media interviews or making comments on the case pending the determination of the substantive suit in court. Farotimi was also ordered to submit his international passport, but following the submission by his counsel that the passport was already submitted at the Federal High Court at Ado-Ekiti as part of the bail conditions granted by that court, where he's also facing trial, the magistrate ruled that the defense team should provide a document from the registrar of the court confirming the receipt of the passport. Citing judicial precedents, Magistrate Adeosun also ruled that senior advocates are not permitted to appear at the magistrate court. He adjourned further proceedings in the case till February 13, 2025. Farotimi's lawyers, while speaking to journalists, said they would work towards perfecting the bail conditions in record time so the defendants can be free from custody. But before bail was granted, I sat down with Senior Advocate of Nigeria, Candide-Johnson, to get his views on why there appears to be no uniformity in the laws on criminalizing defamation and what obtains in some other developed jurisdictions.
Well, every state is entitled to make law as it chooses. You see, all law is about preserving safety, security, progress of an environment. I've heard this said so many occasions that criminalizing defamation is somehow intended to have a chilling factor on freedom of expression. It is fundamental that we have freedom of expression, but it is also fundamental that there is a limit to that freedom of expression. That freedom consists in limiting expression which may be damaging to individuals, to the reputation, to the sanctity, to the safety of the state. These are things which the states and lawmakers have a legitimate right to protect. Now, the idea that defamation is not to be criminalized is utterly preposterous. Every society must determine what type of expression can endanger it. In France, from where I've just come, it is still a crime, defamation. Under the penal code, if you made accusations of a woman as regarding her chastity, that was regarded as something that could lead to a dramatic breakdown of law and order. It is criminalized. In the UK, under the common law until 2010, defamation was still a criminal offense. So there's nothing remarkable about defamation being a criminal offense. What is important is not this fancy argument, which is resolved, and I think will be resolved in those courts by determining whether it's on the statute book in that state or not. It's a simple enough question, but there's no fundamental issue of principle which makes it unacceptable for defamation to be criminalized. Personal reputation is something that everybody who has it is entitled to protect. In many respects, it's more important, as one holy book says, than diamonds and jewels. Certainly, if somebody defamed me, I would be very concerned to defend myself by whatever process the law made available for me to do so. So that is one aspect. The second aspect I think you asked about is as to the whole process and system by which you talk about arrest, etc. Well, you know, the question of whether an arrest is carried out in an orderly or lawful manner is a matter to be determined in that circumstance. As a general matter, if an offense is committed in one state and a complaint has been made, a person that is found anywhere in Nigeria can be arrested and brought before a judge in that particular state. There's nothing new about that. This is simple law. Anybody who read Patrick and Jovens of the States, which I think is a 1972 case, knows that this is something that can be done, that the courts have held up to the Supreme Court, that if a person is brought before a court, it doesn't really matter how they got there, as far as the jurisdiction and power of the court before whom the person is brought. As to whether a person should be arrested violently or brutalized, I think that is clearly unacceptable. This is a human rights matter, not a matter that relates to the defamation or the process that is initiated in that case. Certainly, if excessive force was used to arrest any person, I would find that to be objectionable and something that is worthy of criticism. I would also find it difficult to see a person who has been detained, treated with inhumanity or not given the basic rights. You know, the value and the protection of our system of justice is not just in what it does, it's in what people say and what people think about it. I think that if any aspect of legal process is abused, it is damaging to the credibility, the integrity, and the functioning of the system of justice. And that is something that judges and anybody else who's operating that system should bear in mind.
But what will be your response to those who say that Chief Afe Babalola should have filed a civil suit rather than a criminal suit?
My response would be that when such a person is defamed, they should decide how they will defend their reputation. I will not accept for anybody to tell me what legal process I should use to defend my own reputation. And it's all right for roadside commentators to give a variety of views as to how an individual should protect himself. If my reputation was attacked, I would reserve the right and exercise the judgment, which is personal, as to what process which is available to me I would use to protect it. I don't think it's anybody's business to tell Chief Afe Babalola how he should protect a reputation that he has built and nurtured over decades. Some of the people commenting on this reputation were not born when he was in the trenches.
Have you read the book?
I've seen excerpts. I haven't read the book. I don't have $17.23 to donate, but I've seen excerpts in various social media platforms, which everybody is going to be involved in one way or the other. And the reason why you ask me, I guess, is to what I think about it.
Yes.
What I've read of it is scurrilous and scandalous. I think that truth is something which the entire public has an interest in establishing. If there are bad eggs in the judiciary, if the judiciary is corrupt, if any individual, no matter how large or how famous they are, is corrupt, and this can be established, they ought to be exposed, they ought to be shunned, avoided, and they ought to face disgrace and other penalties. But I think it is entirely irresponsible for anybody, more so a lawyer, to publish in language so, how should I put it, that is so extreme and so abusive. It lacks judgment and consideration. And while the question of whether those allegations are true or not is something which is for a proper tribunal, I think it is important when a person makes such allegations, first that they exercise judgment and discretion. And a lawyer should know that what you can't prove cannot be said. I asked some friends of mine recently who have taken various views on this matter. Can anybody in this room name a corrupt judge? Oh, someone said, well, I know some, but I won't. Some said, I don't want to get into trouble. Well, the fact is that preserving rights and liberty costs. Someone said, if you want to fight for liberty and justice, don't wear your best trousers because you're going to fall on the ground. But then if you have conviction, it's a good thing. But the conviction requires facts. You need to be able to know what is said. If I had it on authority and I was clear that a judge was corrupt, and anybody who knows me would know that I would name the person to their face. I think Chief Afe Babalola knows that if I felt something about him, about his conduct, I would say it to his face. But I wouldn't make a publication in wild, scurrilous, and irresponsible language, which is going to be circulated to the world and not expect to be tested as to its veracity.
I think a lot of people have issues with the way Farotimi is being treated by law enforcement agencies. Leave the man to prove his case. Why lock him up? Why put him in handcuffs?
Well, I was shocked at the image of a legal practitioner being held in handcuffs, not because a legal practitioner, but because legal practitioner is someone who we assume has respect and is going to behave himself, even if the person's utterances belie that assumption. But this offense, which is charged, would be a misdemeanor, maybe 2 years imprisonment. Okay, he's not likely to be violent. I think that the impression I got from seeing that picture was that the intention was to humiliate him, which is entirely inappropriate, entirely unnecessary, and counterproductive. The judicial system depends on its reputation. The law must be vindicated. People must go through the process. But the effectiveness of the legal profession and the effectiveness of the justice system depends on people seeing that it acts in one way for everybody. Nobody can be above the law, and nobody can be below the law. So Farotimi is not below the law, and he's not above the law. Chief Afegbalola is not above the law, but he's not below the law either. The law should be available for everybody. And I think that if it appears that the discretions being made about exercising prosecutorial or criminal jurisdiction are personalized, then it is damaging to the reputation of the justice system across the board.
One of the things Farotimi said in his book was that Chief Afegbalola corrupted the Supreme Court to procure fraudulent judgments for his clients. As a senior legal practitioner who appears regularly before this court, would you say that our Supreme Court is corrupt?
The short answer would be no. I certainly take exception to some of the decisions that have come from the courts or from any judge. But I sit in judgment myself. Many aspects of judgment are matters of impression and of judgment. This is why you give judgment to individuals. Some people say the UK Supreme Court is corrupt. Articles in the Atlantic last month say the United States Supreme Court is corrupt. Why? Because in particular cases where people disagree with them, they have a different judgment as to what should and should not have been done. But the judgment is not ours. I think that anybody who has risen in our profession should have the understanding that the integrity of the structures of our justice system are so important that our first duty must be to protect them. We must protect them against people who will attack them from outside, and we must protect them against those who will attack them from inside. A corrupt judge, a judge who gives inconsistent and unreasonable, patently irrational decisions, is a threat from inside to the system of justice, and such a person should be resisted as well. But that being said, you cannot, having regard to your duty to preserve the system of justice, your responsibility to something that has nurtured you, and something which is essential to the safety and progress and development of our society, you cannot burn it down just on your whim, on your impression, on your prejudice. You have to have facts, because without facts, you are going to vandalize a system which is fundamental and which we all rely upon. With facts, you can surgically extract those who are threatening the system, and you can remove them. So again, to answer your question quite simply, I do not believe the Supreme Court is corrupt. I have disagreed with many decisions they've made, but I believe that this is a judgment that they have been given the power to exercise, and we must accept that judgment.
When people look at decisions from our courts, and I'm talking about all the courts now, and we see inconsistent and conflicting judgments from our courts, doesn't that make the case for those who say that our courts are corrupt?
Sure, there are inconsistent decisions. I think that is a problem of incompetence. It's a failure of administration. There's no reason why a high court should give it. Much of the law is very simple and straightforward. There's no reason why there should be inconsistency in decisions on simple and straightforward issues. Where discretion is allowed complete free rein without the regulation by law and by principle and by precedent, then you have a problem, because then individuals may behave in any way, whether provoked by corruption or not. They can give decisions which people will find difficult. There must be consistency in the law. There must be consistency in judicial decisions and judicial decision-making. You see, I think that you will find that most of these inconsistencies you refer to are in political and politically sensitive cases. This is actually the truth. And I think that it is difficult to avoid the conclusion that many of the judges in those cases are exercising political judgment rather than legal judgment. That is my view. And this is dangerous. And the task of the higher courts is to guarantee certainty in the law and consistency across decisions. That is their job. That's what the Chief Justice of Nigeria should be thinking about.
I hear what you say about the need for decisions of our courts to be certain. But what else do you think that the courts, and especially the CJN, can do to engender trust in our courts and the justice system, especially in terms of reforms?
Our Supreme Court can reduce the time that is wasted in appeals, which allows people to think that the law can be dragged on endlessly. This is part of the problem of defamation. People think that if I go to a defamation court, I'm going to be in court for 20 years, nothing's going to happen. Better to resort to the criminal law. Because people don't have the confidence that judges can decide cases efficiently. And they can't decide cases efficiently and quickly because their procedure is abused, and they allow lawyers, especially senior lawyers, to abuse the process and procedures. The procedure should apply the same to everybody. Efficiently. This is why justice is portrayed to be blind. I don't care who you are. This is the process and the procedure. So that is something that can be done. There are too many cases in the Supreme Court. The Supreme Court grants leave to too many appeals to be heard. Too many interlocutory appeals should not, as a matter of policy, the Supreme Court should not hear any interlocutory appeals. It is important that cases that you can approach the courts in a structured and efficient way. It's important that the courts use their time to decide cases in the quickest way that is possible, because no single case is more important than the administration of justice across the board. That's something they ought to bear in mind. One of the greatest impediments to the progress of justice in our courts is that lawyers are given too much leeway to be dilatory, to be inefficient and incompetent. If you stand up in court and call yourself a senior advocate of Nigeria, you must be prepared. I was talking with a friend of mine who's a judge in Hong Kong, and she was complaining about some of the cases that they do, and some of the lawyers are very unprepared. And I said to her, well, sometimes with our senior lawyers, they don't come to court prepared. She said that would never happen. She's talking about junior lawyers. So you wear a rank, you expect to prove it when you stand up in court, and you must be prepared. But in our environment, people tend to be sentimental and tend to assume that there must be a way. Courts need to make it clear to people that there is no way. The law is the law, even if it's hard.
Welcome back. The Attorney General of the Federation and Minister of Justice, Lateef Fagbemi, has faulted the suspension of the local government chairman in Edo State by the governor, Monday Okpebolo. While fielding questions from newsmen in Abuja, the minister said that it was only the legislative arm of local governments that can sack or place council chairmen on suspension. He also said that under the current dispensation, local government chairmen cannot just be removed or suspended by any governor without following due process of law.
Why I'm a bit reluctant in answering questions along this line is I always want to know the basis. At times, what you read on pages of newspapers may not necessarily be what informed the decision. But one thing that I know, and I can say without any fear, is that under the present dispensation, no governor has the right to remove any local government chairman. That much I know. If I didn't know, since July 11, 2024, I became aware of it, that removal of any local government chairman or official would be the prerogative of that local government through their legislative house. Thank you.
In Kebbi State, Governor Nasir Idris has sworn in 4 High Court judges and 2 caddies of the Upper Sharia Courts. Speaking shortly after the swearing-in ceremony, the governor urged the newly appointed judges to hold judicial integrity by being fair and just in their decisions. He emphasized the importance of maintaining the public's trust in the judiciary. The governor also assured that his administration is committed to the welfare of judicial staff and judges, recognizing their vital role in the society.
The Ministry of Justice in Kebbi State is alive to its responsibility. As far as this administration is concerned, we have never found it wanting. That is why the state government, under my able leadership, is doing everything possible to ensure that the right of judges is being addressed by this administration. I think, as far as judiciary is concerned, we are about to pay our dues. We are live in payment of salaries and allowances to our judges, and they will continue to do that, including privileges.
And just before we go, let's look at the top stories we tracked at the court this week.
We begin with the reports that the Supreme Court has imposed a 5 million naira fine on a former presidential candidate, Ambrose Owuru, for harassing President Bola Tinubu with a frivolous and vexatious suit. Mr. Owuru, who contested the 2019 presidential election against former President Muhammadu Buhari on the platform of the Hope Democratic Party, was ordered to pay the 5 million naira to President Tinubu. Justice Owani Musa Abaji issued the order against the former presidential candidate while dismissing his fresh suit seeking the removal of Tinubu as Nigeria's president. Apart from the 5 million naira fine, the Apex Court ordered its registry not to accept any frivolous originating summons from Owuru again. The Court of Appeal had previously imposed a fine of 40 million naira on the former presidential candidate to be paid to the president, INEC and others for filing a suit against them. Owuru, however, approached the Supreme Court asking it to invoke Section 157 of the 1999 Constitution to remove Tinubu from office. He also asked the Supreme Court to declare him Nigeria's president and order his immediate inauguration to reclaim his alleged usurped mandate. Staying in Abuja, but this time the Federal Capital Territory High Court, where Justice Mary Ananini has granted former Governor of Kogi State, Yaya Bello, bail in the sum of 500 million naira with 3 sureties in like sum. Delivering the ruling, Justice Aneni acknowledged that the offence Mr. Bello was charged with is bailable. The judge added that the sureties must be notable Nigerians with landed property in Maitama or some other parts of the FCT. Mr. Bello was also asked to deposit his international passports and other travel documents with the court. He is to remain at the Kuje Correctional Center until the bail conditions are met. On December 10, the court had initially refused the former governor's bail application, saying it was filed prematurely. His counsel, however, approached the court with a fresh bail application in the alleged 110 billion naira money laundering charge filed by the Economic and Financial Crimes Commission against his clients. Both parties have agreed to a speedy trial of the case. In Rivers State, a high court sitting in Port Harcourt has nullified the ward, LG and state congresses of the All Progressives Congress. Justice Goswill Ogbomanu, in his ruling, nullified the congresses by the party, citing the order of the court restraining the party from going ahead with the Congress, and awarded a 10 million naira fine against the APC. In their reactions, lawyer to the claimant, Emenike Ebete, hailed the ruling of the court, describing it as justice to his clients. On his part, lawyer to the defendant, William Wobodo, said his clients will weigh the court's ruling to decide on their next line of action. In Lagos, the Federal High Court has ordered the final forfeiture of a warehouse built on a landed property measuring 1.925 hectares of land along the Lagos-Ibadan Expressway in Magboro area of Ogun State. The court also ordered the permanent forfeiture of 54 general-purpose steel containers. Justice Deinde Depelu made the order for the final forfeiture to the federal government after the Economic and Financial Crimes Commission (EFCC) moved an application for the forfeiture of the assets since no person or organization came forward to claim them. On November 28, 2024, the counsel to the EFCC, Senior Advocate of Nigeria, Rotimi Oyedepo, had approached the court via a motion of ex parte to seek the forfeiture of the assets. In documents put before the court at the time, the Commission had disclosed that the properties were reasonably suspected to be proceeds of unlawful activity and linked to the former governor of the Central Bank of Nigeria, Godwin Emefiele. Justice Dikbelu then ordered the interim forfeiture of the assets while directing the EFCC to publish the order in the national newspaper for any interested person to appear before the court and show cause why it should not be finally forfeited. And we round off with the reports in Edo State, where the State Election Petition Tribunal sitting in Benin City, the Edo State capital, has resumed pre-hearing on the petitions brought before it by the People's Democratic Party and 6 other political parties challenging the results of the September 21st governorship elections, where APC's Monday Okpeholo was declared winner. Speaking to journalists on the proceedings so far, the lead counsel to the PDP and senior advocate of Nigeria, Ken Mozia, explained that the court is still in the process of looking at the petitions, with the main trial likely to commence early next year. On his part, the state legal advisor to the APC in Edo State, Stephen Okoro, said the court has decided that there will be no separate ruling on interlocutory applications, but one final ruling alongside the judgment.
And this is where we end proceedings for this episode of the program. Don't forget that you can watch these and past episodes of the program on our YouTube channel. Feel free to also get in touch with us via any of our social media handles. I am Shola Shoyele. Thank you for watching and see you next week.